everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this fireside chat with Elizabeth Odette. Elizabeth is the Antitrust Task Force Chair of the National Association of Attorneys General, or NAAG, and the Minnesota Assistant Attorney General. And we're thankful to John Wiegand for moderating today. John is an antitrust attorney at the Federal Trade Commission. If you'd like to learn more about today's moderator or speaker, their full bios can be viewed on our website, fedsoc.org. And near the end of the program, we may turn to the audience for questions. So if you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, John and Elizabeth, thank you so much for joining us today, and I'll hand things over to you.
Thank you, Edie. As an attorney at the Federal Trade Commission, I do need to say that any views that I express in this discussion are my own and may not represent the views of the Commission or any individual commissioner. Elizabeth, welcome to this fireside chat. I suppose you have disclaimers to make also.
Yes, I do. I am not speaking on behalf of the Minnesota Attorney General's office nor the National Association of Attorneys General, but I am very happy to be here.
We may have a technical issue. I'm not hearing you very well.
Let me make an adjustment.
That's quite good right now.
Oh, okay.
Okay, so you might want to say that again.
Okay. I am not speaking on behalf of the Minnesota Attorney General's office nor the National Association of Attorneys General, but I am happy to be here.
So I've known you and had the privilege of working with you in your capacity with the Minnesota AG's office. Can you tell us a little bit about how you were selected to serve in this position with NAAG and some of the responsibilities you have in the position?
Sure. So for those who are not familiar, the National Association of Attorneys General, or NAAG, has it's nonpartisan, and it coordinates amongst attorneys general in a variety of areas, including charities, consumer protection, med fraud, and antitrust. And in antitrust, because we do so many things federally and together, probably several decades ago, it was determined that an Antitrust Task Force Chair would be a good idea to help coordinate those efforts. And so the position of chair is a 3-year term, and it is the selection process goes through the attorneys general that are co-chairs of the Antitrust Committee on the National Association of Attorneys General. Currently, those co-chairs are Colorado Attorney General Phil Weiser and Nebraska Attorney General Jonathan Skrmetti. And so there was a application process, and I interviewed, and then I was told that I had been selected for the position. And so I've been in that role since fall of 2024.
Well, congratulations for being selected for the position. What are the responsibilities that you have that would be beyond what you do just in your position in Minnesota?
Sure. So there are bi-weekly task force calls that we have with all the states that are part of NAAG, and we cover a variety of issues. We make sure that everyone is up to date on things, whether it be various cases that are going on, but also are there opportunities for comments? Are there amicus opportunities? Just other things that we can do to coordinate. So coordinating those bi-weekly calls is one of my responsibilities. Within NAAG, Antitrust Task Force, we also have committees, and they can be industry specific. Like we have one on the pharmaceutical industry, we have agriculture, but we also have generally labor or state action. And so those committees are things that I help coordinate and make sure that we have chairs or co-chairs of those groups, and that they're able to be working on those issues. I also respond to issues that just randomly come up. Who do I contact for this thing? in this state or this issue. And so I'm happy to do that, but that is one of the jobs as well. We also have an education and training committee, but one of my responsibilities is to make sure that we are supporting education and training of all of our members. Then also I do public speaking on behalf of the Antitrust Task Force. And it's meant to be kind of representative of state attorneys general in a whole host of this opportunity being one of them, but it could be through a variety of different industry groups, legal groups, trying to make sure that there's someone that can collectively speak on behalf of all the states.
So you mentioned all the states. Do all 50 states and the District of Columbia have an antitrust enforcement program?
So I believe every state has an antitrust, individuals assigned to work on antitrust. The National Association of Attorneys General does not include necessarily all of the states. I believe there are 3 that are not current members, but that doesn't mean that those state attorneys general and the antitrust staff that are working in those states are excluded from any of the things that the National Association of Attorneys General does. When we have speakers come in and talk to our committees or groups, when we want to coordinate on a joint letter or other things, we do include them. They just aren't necessarily members or lead various committees or other initiatives.
One of the states that's not participating right now is Texas, and I think they probably have one of the larger antitrust staffs among the states. Is that right?
Yeah. Yep. And they're a good example of how we are definitely on multi-states with Texas. I can name a couple right now. The agri-stats case and the pesticides case for Minnesota and Texas are part of a larger group of states. And so we coordinate with them, and we're able to include them in instances where we think that there would be a larger group opportunity.
What are some of the current priorities the task force has for this and next year?
So because months after I became the Antitrust Task Force Chair, there was a change in administration, meaning that there were new individuals that we as state enforcers needed to build relationships with at the federal level, both at the DOJ and the FTC. So that is, continues to be a priority to make sure we connect on all the various issues that we may work on in the future, but also are already working on together. So that is a priority just given the timing. Education and training is another priority. We have seen in the last just couple of years a significant increase in the number of individuals at state attorneys general's offices that are doing antitrust. When I started in Minnesota 5 years ago, I knew a number of people in states who wore many hats. So they were doing charities, they were doing consumer protection, and they were doing antitrust. And so they were just keeping their head above water in the antitrust multi-states that all of the states might have been involved in. And I have noticed in the last couple of years that is very, very few states still have that model, and many more are increasing the number of people that are doing antitrust. Some are creating divisions specific to antitrust, Minnesota being one of them a couple of years ago. But I think both red and blue AG's offices are increasing the antitrust staffing. What we're seeing is that it's not necessarily brand new attorneys that are coming in these new staffing roles, but people with a variety of different experiences and backgrounds. And so we, may have someone who's a really, great litigator, but may not have antitrust experience, or someone who has antitrust experience, but hasn't had any litigation experience, because antitrust cases, as we all know, take a long time, and those litigation experiences are not as frequent as they are in other areas. So one of the priorities that we have is to try to make sure we're providing the right training for the group that we now have, and just support this larger group of state enforcers that we have. Oh, and then one more priority is to promote the good work of the state enforcers. I should have mentioned that as one of my responsibilities, but I have seen since I took the role that, and in timing with the new transition, that people are kind of waking up to state enforcement and thinking, will state enforcement increase given the current status of the political climate? And I think that if people look at the state enforcement in recent years, you'll see that state enforcement's already been there doing a lot of good work. And maybe it just went unnoticed with all the other activities at the federal level, some of which the states were participating in. But there's always been great work done at the state level. I think I would just frame it as maybe it's getting more attention because states, and are increasing their antitrust staffing. So they're maybe doing more that can be gets the attention at the national level.
Sure. So because I work at the FTC, the model that I see is cooperation between the FTC and a state AG office when I have a matter that's situated in a particular state. So, I see the relationship as a partnership where the state AG's office will work with us in an investigation. But are there kind of other models where you're working, states are working alone or they're working in concert with other states? Can you give us a little bit of background on that?
Yeah, so you're right. I think there are a lot of instances where we work and partner with the state, or the states partner with the federal enforcers. And I think in those instances, it's a really good partnership, I think, because states are able to give some local knowledge and flavor to the investigations. States do have their own multi-state cases going where there aren't any federal enforcers as part of it. One is the generic drug case in Connecticut. And that is a huge, giant, long-standing case. One of the examples I would say of where the cases take a while, so those opportunities for certain litigation experiences may not happen for a while, but that case is getting very close to the end. Suboxone is another example of a case that I think settled about a year plus ago in the pharmaceutical area where that was state specific and state led. I think that states try to work together where they can, and that those both are, pharmaceutical examples. And so that is where, there may not be as easily found borders for those things. And yet, because it involves something that is so important to the constituents that are contacting the offices, namely the affordability of prescription drugs, that states have, found that in those instances, it was important to prioritize.
Do states occasionally bring antitrust matters to court where the effects are solely within a state and they're doing it on their own?
Yes. So I can highlight one example, very recent win for the New York Attorney General's office. They sued to stop a merger of two ski resorts, or two ski resort companies that own certain ski resorts in New York. And they alleged it created a monopoly in the Syracuse market that would cause skiers to suffer higher prices and more crowded mountains and facilities due to the lack of competition. And they were successful in that. And it was a very rare, but hopefully not as rare going forward, interpretation of the Donnelly Act, their New York antitrust law.
So I guess it's important to point out that most states have antitrust statutes of their own, and in addition to enforcing those, they can bring cases in federal court under federal law, right?
That is correct. Yes. Not every state has their own antitrust law, but most do. And often the states are using a combination of federal and state when they are looking to sue under antitrust law.
And the contour of those state statutes can be a little different in some states than the contour of Sherman and Clayton Acts, right?
That is correct. Yes, there can be some really unique local nuances. One of the areas, though, that I think probably is just really easy to see is the amount of civil penalties or damages that can be sought, and that can vary greatly. And I want to say that Alaska might be one of the ones with the highest antitrust, over $1 million or $10 million in damages if you violate Alaska's antitrust statute.
Well, everything's big in Alaska, so I guess we could have predicted that one.
Yep.
So you've already mentioned some kind of enforcement highlights. Are there some other matters in progress that you'd like to call some attention to, and you think our audience would like to know about?
Yeah, so there's a couple of areas in addition to that very unique one that was specific to New York and kind of limited to their borders. State attorney generals have sued pharmacy benefit managers under their state laws. So Ohio, Hawaii, and then last week, Michigan sued over a very specific leasing agreement between Express Scripts and Prime. So state attorneys general have specifically leapt into that area. And then also Nebraska Attorney General in November filed an antitrust lawsuit against some of the really large heavy-duty truck manufacturers, accusing them of limiting the availability of diesel-powered semi-trucks in a shift to clean energy trucks. And it relates to certain environmental regulations. And similarly, a coalition of 11 states, I believe led by Texas, sued BlackRock, State Street Corporation, and Vanguard over the constriction of the market for coal, and alleged that those are anti-competitive trade practices. So states are kind of, like I mentioned earlier, like looking at specific areas and where they see something that is important to them and their constituents. They're looking to bring actions themselves.
Now, I know this would not be necessarily an enforcement priority, but a legislative priority for the past few years had been the State Antitrust Venue Act. That was passed by Congress, and can you give a little bit of background as to the purposes of that and how you see the passage of that act changing the state practice?
Yes, Minnesota and other states, I believe almost every state was in support of it, as was the FTC and DOJ. And federal enforcers are able to sue in the jurisdiction of their choosing. Obviously, venue challenges can happen, but states attorney general, prior to the passing of the Antitrust Venue Act, were not included in that part of the statute. And so were subject to the judicial panel on multi-district litigation in being transferred to a venue where a multi-district litigation occurred. And that did happen in our generic drug case. It was a case that was originally filed in the District of Connecticut by the Attorney General of Connecticut. And it then was transferred to Pennsylvania, where a multi-district litigation had formed. And that is challenging for states because states attorney generals don't have to do class certification. They don't have to improve certain aspects of a class. And so to be subject to a scheduling order that is much more spread out than would be necessary for a state attorney general's claims, potentially, it limits things in terms of evidence can get old. It makes things more costly because you're still having to move litigation forward, but in this much slower pace. And so, arguments were made that states should simply be able to have the same ability as the federal enforcers on this issue. And we're successful. I would say I remember very specifically some of the arguments that were made against it at the time, that there would be 50 lawsuits in 50 states over one potential antitrust issue. And I think the argument in response to that, or the response to that, would be, we are still limited by our budget, by our resources, and have to choose wisely in what cases we bring and how we bring them. And most states would tell you that our preference is to work together. And I think you see that in as many places as there can be coordination, we work together to coordinate things. However, there may be instances where filing locally is the best thing for that state because of its unique circumstances, because of the law in that location that you want to be able to sue under and not have buried under, a whole host of other issues that are raised in a class action. And so, it took a little while for things to get moving once the State Antitrust Venue Act was passed, because there was some question over its retroactivity. But ultimately, the generic drug case was remanded back to the District of Connecticut and is moving swiftly now there. And I think one of the cases that you saw it most prevalent was in the Kroger-Albertson merger challenge. So there in Oregon, the FTC in 9 states sued for a nationwide preliminary injunction, citing concerns that the merger would harm competition and consumers. But also,
which we want.
Yes, you did. We did. I mean, I get to talk about this case because Minnesota was not part of it. We do not have a Kroger or Albertson. So I was a enthusiastic observer of the 3 different actions that were going on, but not having to expend my own or any of Minnesota's resources on it. But Washington Attorney General sued in Washington, and Colorado Attorney General sued in Colorado. And I think what you saw in the hearings and trials that occurred for all 3 matters, but particularly in the 2 states that brought the actions themselves, they were citing some really specific local impacts. I know Colorado for sure had public meetings about the merger to gather information about what the local impact was. And I believe Colorado's district court decision is still pending on Colorado's allegation of no poach and non-solicitation agreements during a strike that happened. So there, again, that's really very specific. But I think this Kroger-Albertson merger challenge demonstrates that there weren't 50 lawsuits. There weren't even lawsuits by all the states that had Kroger-Albertson stores that may have been potentially harmed. There were very specific state decisions made, and for Washington and Colorado, they decided, this was an area of high importance.
So the decisions by Colorado and Washington to bring actions in their own states, that did not foreclose in any way other states from partnering with the FTC, right?
That's correct. Yep.
So,
and I believe I will just say, even though there were 3 different litigations going on, my understanding is that discovery was coordinated so that there was, I believe all of the courts would expect there to be coordination so as not to put undue burden on any of the witnesses for evidence.
shifting gears a little bit here, One of the trends that I think practitioners are noticing is that some states are now requiring pre-merger notification, just like the federal government does under the Hart-Scott-Rodino Act. Do you see this as an increasing trend, and where do you see this going?
Yes. So one thing I will point out in the new Hart-Scott-Rodino Act form is that there is a section that you could overlook, but please don't overlook it, that is for state attorneys general, and it's voluntary, but it allows those making the submission to allow the information being provided to be provided to states. And you have to list the states, and you have to check a box that says fact of notification and waiting period, and or information and documents. This is important, I would say, because a lot of time and energy unnecessarily can be expended dealing with waivers that state AGs may need to get, more so on the DOJ side. But it's something that we have various statutes for confidentiality and protection of information in investigations. They don't significantly vary so much that I think parties should be concerned about sharing information with states. I think, and this will get to the point about the pre-merger notification laws, I think most would want to be able to only be sharing information in one way, to everybody who needs it. And so to be sharing the HSR form and information contained within with relevant state AG's offices, it's a step that I think would be efficient for all, but it is voluntary. We, I think, pushed for it to be maybe perhaps just required, but each state can decide for themselves how they want to do it. But I think we're still a bit early in determining whether and how often this voluntary checkbox gets used. But to your question about the state merger notification laws, I think they fit into a couple of different buckets. So one is the very, very basic state law that would say, when you submit an HSR form, give it to the state AG's office too. That's kind of a base level if you have one. And that means that they're not necessarily getting anything below the threshold that might impact their state, but at a minimum, they're getting information, because without a state notification law, states are dependent on the parties or the federal government to find out when when something might be happening that may be impacting them. That means that we are definitely going to be on a time crunch in trying to figure out what information we need and how to assess it. And I would say that some parties are worried that if a state AG is going to get involved, that they somehow are going to try to make trouble. And I would say that for a lot of these pre-merger notification laws, it's not necessarily that they want to slow things down or stop transactions from happening, but simply collecting information. So in Minnesota, we have one that was passed in 2023 that's specific to healthcare. And it is in conjunction, we work in conjunction with our Minnesota Department of Health. And, they have economists, and they are simply trying to collect information about markets in our state to better inform the legislature when they come up with these ideas on how to regulate. Perhaps having better and more information might help them from creating bills that might be more problematic than helpful. But I got off track. So we've got the very basic, HSR checkbox of give me what you're giving the federal government. The Uniform Law Commission has recently developed a pre-merger notification uniform proposed bill. And this is meant, I think, to try to give states similar information and give it to them in a timely manner, but in a way that's uniform. Because right now, what has been happening is many states are passing laws, and it's a bit of a patchwork. And can be difficult for those trying to advise clients or just work on mergers and acquisitions. Washington recently passed that, and I think that that is helpful because they also had a healthcare notification law. And so there was some question about how a ULC proposed standard merger notification law would look to a legislature who passed a industry specific law. And it seems that they were able to work and have both of them and not have them conflict with each other. So I found that that was helpful. I would say that industry specific, most often I'm seeing in the healthcare industry. And I think that makes sense because states and, healthcare is very local. And so state legislatures also, in terms of budget for household and budget for legislatures, our state is grappling with a budget year this year. Healthcare is a pretty big chunk of it. And so trying to figure out, well, what can we do to have more information about what's going on in these markets if we give the AG's office the ability to get notification and then just collect information that could be helpful down the road. Some states like Oregon have their own separate agency that handles healthcare transactions. But I would say the majority of them that are being passed on healthcare are with giving the Attorney General additional antitrust and charities tools.
Have you seen some benefit already from some of these pre-merger notification statutes? Does it allow a state to investigate more efficiently? Or does it permit the investigation to be completed before the merger is consummated? Do you have any feel for what the practical effects have been so far?
Yes, so I can speak more personally to the experience we're having in Minnesota. What has been interesting for us is our law requires 60 days with all the information getting in. It gives us the ability to seek an additional 90 days if necessary, not seek, but just tell them we need an additional 90 days in writing. But our practice is if we're simply trying to make sure we're complying with the statute and collecting the information, and we are able to determine in the time required initially under the law, 60 days, we're going to try to do it. So the more information that they can provide to us early and, coordinate with us on what additional questions we might have, we've been able to, I don't think we've been an impediment necessarily to any of the entities that have submitted to us. And so that's helpful. I would say though, that's one thing that's interesting with the 60 days is that that is more than the 30-day that the federal enforcers have for the HSR form. And so it has been my experience now that in some instances we learn first about something going on before the FTC does. And that's new to me because as you and I mentioned in the past, the FTC reaches out to the states typically. But I think, as I mentioned at the beginning, it's, I think, helpful for parties to be coordinating with both because it, is necessarily, each has their own, their own job in this, kind of space. But I think the other thing that has helped us is it has given us a better sense of what our Department of Health does collect in terms of data that could be helpful to us. And they've learned from us about our processes. And so I think we are less often going to maybe step on each other when we're looking at a transaction, which, it's not good for us and it's not good for the parties because then you might be at cross purposes when you're trying to work on closing a deal.
Wanted to talk a little bit about how you work to try to build a consensus? Because I think a lot of our audience would be thinking, she has a pretty wide philosophical diversity among state AGs and how they're going to approach antitrust. Can you talk a little bit about how you try to work through those hurdles and have some common ground among states and common ground in working with the federal agencies as well?
Yes, so that is a constant discussion amongst states. I would say where you see it most prominent is whether and to what extent states will start to investigate something, either collectively or as part of a state group or as a federal group. There may be some state AGs that look at an initial issue and go, this doesn't align with what we are thinking an antitrust violation looks like. And so, good luck to you, but, we'll put our efforts elsewhere. But I think there are still a number of areas where the different theories of antitrust still can work together, and we're seeing that. In particular, there's certain cases that are multi-state cases that we're with the federal government on right now. I can think of like Live Nation Ticketmaster has over 30 states. It's not hard to get consensus on people disliking the amount of money you pay for your tickets these days. But I would say that each state has its own sovereignty. And so it's different than when I was in private practice and working on the plaintiff side, where you had a lead plaintiff, and that lead plaintiff's firm got to ultimately make decisions. And in state multi-states, each state can make a decision about a strategy. And so you need to come to consensus quite often because you can't move forward without consensus. And ultimately, I think that leads to good decision-making because you just have to listen to each other and can't kind of stay in your own, box and try to just push things forward on your own. So I think that's kind of what we do. We have a joint enforcement committee that, works to put together where we have common ground on moving forward with procedures and processes. We can articulate those either in trainings or in draft documents so that we can, where we have consensus on how to move forward on things, great. If not, I think we just try to stay out of each other's way if we don't have any need to be in a particular space. So that I think is how we manage those types of differences.
I suspect a good part of our audience today are attorneys in private practice who are primarily either on the defense side or they're representing parties to mergers. Do you have any practice pointers that you might share with them about working successfully with states, either in the context of a merger or if they find that their client is a target of a state antitrust investigation?
Sure. So we, at least in the Minnesota Attorney General's office, have an open door policy. And so our AG is open to hearing from anybody. I have been part of presentations by entities who believe they are a target, and they're informative and helpful to us. I would say the presentations that are most helpful are those that don't expect any questions, because as you know, John, the fact of asking a question might reveal too much about what you know or do not know. And so sometimes when entities come into a meeting like that expecting a dialogue and don't get one, they might get frustrated. And it's not because we aren't being rude or don't intend to dialogue. It's simply that we are unable to do much in engaging back and forth without just, potentially disclosing something. And so, but I would say it's still helpful to get, a presentation from and information from an entity that may be targeted by other states, right? And may think that, this state AG is next. I think for mergers and acquisitions, especially for those states that have those pre-merger notification laws, and you have to achieve some sort of hurdle in a state, dumping it all on the state 60 days before you want to close something is not helpful. And what's more helpful is at least we have a web page that tells you, hey, here's some things you already know about yourselves that you could tell us in advance of working out those little fine details like the definitive agreements, and giving us that information to kind of noodle on while you prepare your final papers is great for us, because that helps us know a little bit more about you. And it's not, again, necessarily to try to find a problem. It's simply to help us understand who you are, what you do, what are your goods and services. And, then we might have less questions down the road because we've had time to just get those basic facts under our feet.
I think a lot of antitrust practitioners are familiar with the confidentiality rules that apply at the federal level, both at the DOJ and at the FTC. What confidentiality rules apply to state AGs, and do you sometimes have some difficulties when Public Records Act protections kind of rub up against the confidentiality concerns?
Yes, and so I think that is where the angst comes with the waivers for information sharing between the DOJ and states when a merger comes along, or even a conduct investigation. Each state's data practices acts are a little different about how the information is kept and when that information may be subject to disclosure. I would say, though, very generally, states are really pretty careful about the information provided, because for a state to have a data practices request require the disclosure of something that is intended to remain confidential, it's unhelpful to us, because then our investigations, it's harder for people to trust us. And so know that we are doing our best to make sure that our data practices will protect investigative information as it moves forward. And I think, as states, when we come together in multi-states, we have common interest agreements. We try to, through each step, protect information. Even with our state healthcare transaction law that I mentioned in Minnesota, we're working with the Department of Health. They have different data practices requirements than we do. And we have figured out how to make sure that there is not an unintended disclosure to them that could potentially put at risk information that's being provided to us under those laws. We still have the ability to disclose things for really, really narrow purposes. But I think those instances are probably out there in the press. And if your case is not one of those, then you're probably good.
You mentioned earlier in our discussion that the historical practice has often been that the federal agencies find a matter, either a pre-merger filing, or they identify a conduct matter and then reach out to appropriate states. But you also mentioned that with the states having pre-merger notification laws coming into effect, that may reverse the process, and states will be reaching out to the federal agencies. One of our questions in the chat was about, do you find relationships in both agencies where you could reach out, or would you call DOJ or FTC exclusively? What do you think the practice is going to be on that point?
So I will say that the Department of Justice, Antitrust Division, and the FTC each have liaisons that interact with the states. They're the state liaisons. We've had them for each administration that I have known since I started 5 years ago. And so usually the practice for when we have a question, like, is the DOJ looking into this thing, is to go to one of those liaisons, and then they get us in touch with the right folks. As you know, sometimes it's unclear whether some conduct may be, or even merger may be in the DOJ camp or the FTC camp. So we usually will contact both if we are wondering. And we're usually given the direction, the right direction, or the right people to talk to. And I would say that, even under the new administration with I think we have a new liaison for the FTC. We have the same liaison for the DOJ, that those communications back and forth about various matters have continued.
And I could say as well that it's not unusual, because I practice in the healthcare sector primarily. It's not unusual at all for state AGs to call me directly and say, what do you think about this? Or do you know about this transaction or this conduct? Are you aware of anything, any federal investigation about it? So I sometimes receive those calls directly, and I think staff attorneys do across both agencies if there's been prior partnership relationships and people feel comfortable reaching out outside official channels. So I think that happens quite a bit.
Yeah, and I'll give one example of recent, I think in the last year and a half, there was a case that certain states brought against the NCAA related to student athletes and the transfer rule. And DOJ ended up joining that litigation. And that was kind of a new one for us. I don't know if that had happened before, but my understanding of that was, individuals had reached out to AG's offices about that. And it makes sense, right? Those schools are located in states, and they wouldn't necessarily be thinking to contact their federal government about those concerns. It was their state AG. And so I think there are and have been issues that just simply make more sense for individuals when they come across an issue, whether it be antitrust or otherwise, contact their state AG, because that's at least someone in their community that they know to reach out to. So but as you said, it will go back and forth, and those relationships within the various agencies do help facilitate.
We have another question in the chat that relates to agreements among competitors regarding so-called ESG issues. The question in the chat references specifically energy codes or energy standards set by competing entities. Is that an area of concern among state AGs?
I am not sure. I think it might fit in the same vein as the cases I mentioned that Nebraska and the Texas attorneys general is leading related to certain environmental regulations. But I'm not entirely sure about this one specifically. I haven't seen anything public about these specific concerns.
We also have a question in the chat about the right to repair. That was an issue that was raised by the Federal Trade Commission a few years ago. Is that currently an interest of your task force, or do you perceive it being an interest of individual state AG offices?
So yeah, I have a few things to say on this since Minnesota joined the FTC in the Deere case, which specifically involves right to repair issues. There are state legislatures across the country considering and passing right to repair laws. And so I think it's an area that is getting a lot of attention. Minnesota passed one, but it had an agriculture exclusion. Colorado has one that includes agriculture equipment. The case against Deere includes, I think there's 5 states, Minnesota, Illinois, Arizona, Michigan, and Wisconsin. And the FTC, and it's venued in Illinois. And what I find interesting about that case is something that may not be on people's radar is the intersection of tech and agriculture. And this very much goes to an ability of a farmer to fix their equipment, which is a huge multi-million-dollar investment. But the technology that runs it may limit them in their ability or independent repair shop's ability to fix it. And farmers have very limited windows of time to be doing certain things in the fields with their equipment. Right now, Minnesota is in one of those. I heard from my family who lives up north in Minnesota that lots of planting out in the fields going on right now. And so if something breaks down and they are unable to do that, that could be quite costly for them. And so that case is in its early stages. It was just filed in January, but I think you may increasingly see either legislation or other cases related to the right to repair issue.
Yeah, I think we have exhausted the questions. Are there any other topics that you'd like to share with our audience today before we wrap this up?
I don't think so. I think what I would say to everyone is thanks for giving space for the state attorneys general across the country. I think sometimes I've been in a room at a seminar where they're talking about state attorneys general as if we're not there. And so it's nice to be given the opportunity to talk to you all about the work that we're doing, and hope that I was able to impart some information to you that you may not know about how we work and what we do. But I would encourage people to reach out to your state attorneys general. And if you don't know who to reach out to in your state and want to know the right person in the antitrust groups, I am happy to facilitate that. That is part of my job. And I would say it's a great group. They're really good, smart people, and all are happy and willing to talk with you if you have questions.
Thank you very much, Elizabeth. I think we'll turn things back over to Edie for all of the details from the Federalist Society view.
Yes, on behalf of the Federalist Society, thank you so much to Elizabeth for speaking with us today and John for moderating. We really are grateful for your time and expertise. And thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and other upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, everyone, and we are adjourned.